Are we ready?
We are now live.
This is the man behind the curtain. Good morning.
The chairman is not going to flash live.
Why don't we get started? Good morning to everybody, and thank you for being here. This is the press conference that I do regarding legislation the day before a legislative meeting, and tomorrow, July 13th, we will have a legislative meeting. It's an additional meeting of the council, which means the agenda is somewhat limited. It also is the last legislative meeting of the council before we break for recess. And if that sounds a little odd to those who follow the council in the Wilson building closely, we are amending our rules, the council rules, so that we'll be able to consider the budget during recess. So we have a legislative meeting on July 20th, which will be first reading on the budget and the Budget Support Act. And there's some other related bills like the supplemental for the current fiscal year. We will have second reading on the budget on August 3rd, and we will have final reading, second reading on the Budget Support Act August 10th. That's our schedule. But the rules change tomorrow will authorize the council to be able to adopt the budget legislation during recess. Will limit any other legislation to that which is related to the COVID pandemic. And as you know, we have been from time to time passing legislation, emergency legislation regarding the pandemic. And so it's possible that there might be some legislation. I'm not predicting, but it's possible there might be some legislation like that on July 20th, August 3rd, or August 10th. So tomorrow is the last legislative meeting before the recess, and it will be preceded by a committee of the whole meeting. And the committee of the whole is going to be marking up 4 nominations to the Historic Preservation Review Board, 1 nomination to the Zoning Commission, and I believe it's 5 nominations to it might be 4 to the Out of School Time Grants and Youth Outcomes Commission. That's markup in the committee of the whole, and we will be considering from other committees a number of confirmations. We don't mark them up, we just move them through to the legislative meeting. So all of that will be on the legislative meeting tomorrow following the committee of the whole. I believe there's one bill which is coming out of Committee on Health, which is the Certified Midwife Credential Amendment Act, which I don't believe is controversial. Everything else, and it's a rather long agenda, is nominations, confirming nominations by the mayor. So that's committee of the whole, followed by the legislative meeting. The legislative meeting, in addition to all those nominations, will be doing some contract legislation, which I've not looked at closely, so please don't ask me questions about it. And then emergency legislation. I'm not looking at the order of the agenda, but probably one of the emergencies that is gaining attention for tomorrow is what are we doing with the public health emergency? The mayor has indicated to us that she doesn't want to continue the public health emergency. And so what we will be moving tomorrow is an extension of her authority with regard to the emergency, but not the public health emergency. And that means that we have to be looking at all of the measures, and there were maybe 24 that we put in the COVID emergency legislation over the past year, relating to all kinds of issues like debt collection, utility cutoff, evictions, rent increases, tolling of different deadlines in the statute. And we are, for that which is still in effect, we are going to be adopting triggers. And maybe triggers is the wrong word, extending those provisions for the most part until November 5th. And that's intended to give the committees time to complete their work if they haven't already started, if they want to make any changes to the permanent law regarding those different measures. Separately from that, and I'm going to see if I can remember this, there are a number of provisions that will not be subject to the November 5th deadline. For instance, we have a prohibition on rent increases That will be continued through the end of the year. If we don't continue to the end of the year, then they can begin as soon as the public health emergency ends. So we're giving basically another 5 months grace period for tenants. Evictions and utility disconnections are going to not have the November 5th deadline because we have separate legislation. No, we have a separate provision within the emergency. It's within the same emergency. We have a separate provision that gets a bit complicated in how we're handling utility disconnections and resuming the eviction process. I'll come back to that in a moment. Unemployment insurance, we have some provisions in the emergencies that we've passed. Emergencies have been accompanied by temporaries. The current temporary will expire next February. And so the changes that we put in place regarding unemployment insurance will run with the temporary. That is, they will continue until February 5th. I think it's February 5th. Let's say February. Which one am I forgetting? Okay. Utility, evictions, rent increases, unemployment insurance. Everything else will have November 5th. No, debt collection is another one. That's the 5th one. I'm moving a separate emergency tomorrow regarding debt collection, so that'll just come out of the COVID emergencies that we've passed. I hope I'm not confusing anyone. But as I said, there are about 24 provisions that we've enacted through the COVID emergency legislation over the past year, extended periodically, also covered by temporary legislation that expires in February. And most of that, as I say, will be November 5th, and those 4 exceptions will be different. With regard to debt collection, the emergency that I'm moving tomorrow updates the law which was adopted in 1971 by Congress and has had only minor changes since 1971. So for example, our current debt collection statute says nothing about voicemails, is not applicable to credit cards or medical debts, and really doesn't limit in the way that the federal law does communications from debt collectors to individuals. So that's what the emergency tomorrow addresses. And we've worked on this with the Attorney General, who I believe is putting out a press statement today regarding the legislation. So we are expanding the definition of debt to include all consumer debt. We're prohibiting excessive communications that essentially amount to harassment, including making more than 3 phone calls in a 7-day period, prohibiting making more than 3 phone calls in a 7-day period, prohibiting other deceptive behaviors that the current law, again, adopted 50 years ago, didn't contemplate, such as prohibiting threatening action the debt collector cannot take, disclosing disputed information without disclosing that it is disputed, prohibiting threatening to disclose false information, prohibiting initiating causes of action where the statute of limitations has expired, prohibits seeking to collect funds exempted by state or federal law, or seeking to collect debts owed by deceased consumers, seeking to collect it from those with no legal obligation to pay those debts. The legislation better defines the documentation that a debt buyer or other third party must possess prior to bringing a claim, incorporates the protections in the Federal Fair Debt Collection Practices Act, and places a reasonable cap on attorney's fees that have to be paid by individual consumers. So those are the provisions that will be in the debt emergency that I'm moving tomorrow. Which is called the Protecting Consumers from Unjust Debt Collection Practices Emergency. With regard to evictions and evictions and utility disconnections, if we do nothing, The utility disconnection moratorium that's in the current law will end in early October. And if we do nothing, the landlords would be able, I believe, immediately to start filing or sending notices to tenants and filing cases, I believe, 60 days. In 60 days, 2 months. So what we're doing is trying to create a more of a soft landing, and also making a distinction between low-income individuals, those who have greater difficulty in being able to handle debt like rent or utility bills, distinction between them and those of middle and upper income means. So with regard to the utility disconnections, low-income residents will be protected for an additional 90 days if they owe less than $600, or if they received or were approved for benefits under existing benefit programs such as LIHEAP, Stay DC, CAP, which is a DC water program. They also will be protected longer if they're receiving SNAP or TANF. And they also will be protected longer if they're over 21 and are receiving either Medicaid or benefits under the DC Alliance. So this is how we're continuing protections for lower income individuals. In addition, utility companies will have to provide notice to customers 60 days in advance of any disconnection, suspension, or degradation of service. And consumers could have their service restored by entering a payment plan of at least $10 a month. So those are ways to extend the protections for individuals and softening the end of the utility disconnection moratorium. With regard to the evictions, we're going to continue the, actually there's still going to be limitations on evictions, but there's still going to be an exception that was adopted by the council a couple months ago regarding public safety. We're not making any changes to that. What that refers to, for example, as an example, somebody's been busy firing a gun in their apartment and doing a meth lab in their apartment, that would be a public safety exception. They could be evicted. That's what we changed in the law back in April. We're continuing that. The bill provides 2 more exceptions to the moratorium where a tenant has willfully or wantonly caused significant damage to the unit or the common areas, and significantly damaged is narrowly tailored to ensure that housing providers cannot evict a tenant for minor cosmetic damage. It has to be significant. We're also providing an exception for housing providers of 4 units or fewer if the housing provider can demonstrate they're experiencing severe financial distress, and that's defined, so we don't want just an allegation. There has to be evidence to the court that that the housing provider is experiencing severe financial distress. Remember, we're talking about owners of 4 units or fewer, and so that could be, for example, an individual who has 2 homes, one they live in, the second one they rent out. I mean, we're talking about just individuals, not big corporations. And the housing provider would have to demonstrate the tenant's ineligibility for rental assistance at the time of filing. Under the emergency and temporary legislation, non-payment of rent cases, where there's the allegation is non-payment of rent, those cases could be filed beginning October 12th. To file such a case, the housing provider must either apply for rent assistance on behalf of the tenant or initiate the application for the tenant and wait 60 days. If within that time the application is not submitted or the tenant is found to be ineligible for assistance, then the housing provider could move forward with an eviction filing. So we're linking relief programs such as Stay DC to the ability to evict. And where the application was filed, the landlord has to wait. Where the tenant is ineligible for the assistance, then the landlord could proceed. But that doesn't mean that they can actually evict on October 12th. It means that the cases could begin to be filed then. Eviction cases not covered by the exceptions or that do not involve non-payment of rent could be filed beginning January 1st. And this is to try to reduce what could be an avalanche of filings, to spread it out. The emergency provides other protections for tenants so that evictions do not return to normal pre-pandemic practices, including a requirement for notices of past due rent, requiring notices be in the tenant's native language if the housing provider has that information, requiring that the summons be served to tenants 30 days before an initial court hearing, and providing tenants with defenses in court where they can show housing providers have not fulfilled requirements of the law in good faith. We also changed the law a few months ago, actually it might have been last fall, to prohibit eviction filings for non-payment of rent if the amount owed is less than $600. To summarize, the low-income tenants will be protected because the housing provider will not be able to proceed with an eviction case for non-payment of rent unless the housing provider has applied for assistance from Stay DC and waited 60 days. As a practical matter, if Stay DC will pay for the tenant's rent, then there's no basis to evict the tenant. Tenants will also benefit, low-income tenants will also benefit rather than general protection from eviction for 60 days after next week when the public health emergency expires. Tenants will be protected except for limited exceptions I mentioned, such as public safety, until January. And by making Stay DC a predicate to eviction, more low-income tenants will have their debts eliminated, so they benefit that way. That's low-income tenants. All tenants will benefit in that extremely problematic neighbors, such as those committing crimes of violence at rental property or causing significant damage to the property, can be evicted sooner. Housing providers will benefit in that extremely problematic tenants can be evicted with case filings allowed immediately for tenants who commit crimes of violence at the rental property or causing significant damage. Small housing providers will benefit by being able to file eviction cases if they can demonstrate that they are experiencing severe financial hardship or the tenant is not eligible for rental assistance, then the housing provider's financial distress will be mitigated or relieved by recovering possession of the units. So it's intended to have a more thoughtful end to the moratorium, and also to, as I said, soften how quickly that moratorium ends, depending upon one's income means. I mentioned before that we are amending the rules tomorrow to permit the council to consider budget-related legislation, but otherwise to cut back on its business. And we're extending the recess from September 15th to the end of September. The other measures that are on the agenda as emergencies, I think, are not going to get as much attention. Emergency that Councilmember Che is introducing to allow the Green Finance Authority Board to meet in spite of current quorum requirements, and approving rulemaking regarding electric vehicle public infrastructure expansion, allowing an apartment building, Kennesaw Apartments on 16th Street at Irving, to be eligible to apply for targeted historic preservation assistance, which currently is limited to homeowners, and to authorize on an emergency basis the disposition of the Wilkinson School to a charter school, the name of which I can't remember at the moment. It's where the Infrastructure Academy is. There's a hearing on the permanent legislation today. And I think those are all the issues that are on the agenda for tomorrow. I don't know if you all got copies of the agenda. So I don't know if there are any questions. Yeah, I'm sorry, Aston.
So when does the emergency kind of all the protection end? If should the mayor not extend it? Because that's your question.
Well, the mayor, all we do is give the mayor authority. So she can end or start whenever she wants to. If I remember correctly, the public health emergency, and the authority ends July 25th.
And it's your impression that the mayor will extend it beyond July 25th.
Not only is it my impression, but the bill that I'm moving tomorrow will not give her the authority to extend the public health emergency. But it will give her the authority to continue the emergency. It's pretty much related to federal funding. And I know that I saw some email traffic over the weekend concern about whether this would affect federal funding for homeless shelters, like in the hotels. And I've received assurances from the executive it won't, because the FEMA, that's through FEMA, and the FEMA authority is through the emergency, not the public health emergency. So in the public health emergency is what's given the mayor the ability to restrict openings of businesses, for example, or to require us all to wear masks. And that goes away when the public health emergency goes away. Yes.
So to be fair,
Yes.
I also underheard
Oh yeah, I left that out. Depending on what version we were looking at, there were a lot of tweaks or a few tweaks, and I'm not sure I would call them tweaks. The bill has two changes: that the program allow landlords to apply on behalf of tenants with a tenant's signature or consent to the application portal. The executive hasn't been real clear or good about that, and the federal law allows that. The tenants benefit if their rent's paid. They no longer have debt. The landlord has a financial incentive to file because the landlord gets the rent. So if the tenant isn't moving quickly, or there are just other access issues, access to the internet, ability to figure out all the documents that have to be uploaded like the lease, so the landlord can do that. That's we're making that clear. And that the second change is the executive issue guidance on covering internet arrearages and security deposits, both of which are allowable expenses under the law and the federal law and Treasury guidance. Now, there's been some other changes that have been discussed, like for instance, no longer requiring social security numbers, but they're no longer requiring them. So we're not prohibiting that because it's not being asked for.
I know that there was a meeting to like discuss this part of the and that sounds allowing self-attestation to the that federal guidance allows, right? And I wonder, my question is, are you confident in this in safety as is right now? Do you think that state dollars are gonna actually, are you confident in this program?
Now, you know, you're asking me a different question.
I'm asking, is this your question? Are you
I'm
confident?
very concerned
Yeah.
with the pace at which those dollars are getting out the door for two reasons. One, tenants and landlords need the relief as quickly as possible. So this ought to be happening. I'd like to see all $352 million obligated yesterday. And I'm also concerned because, as everybody knows, that there could be that money will go back to the federal government if it's not obligated by the end of the fiscal year, September 30th. So want to see this money going out the door quickly. My staff has been working with a lot of the legal services providers and others who are in the thick of this to figure out where there are impediments, many of which are, what do I want to say, self-sustained as opposed to something that's in the federal law. In fact, most of which are self-inflicted. That's the word I want to use. And but the state DC is figuring those out. And it actually appears to me the biggest problem right now is that they're just not processing these applications quickly enough. There's still a communications problem, and actually, if there's a competition for the biggest problem, it might also be communicating the program to individuals. So I can tell you that if I'm talking to a tenant who says, anywhere in the city who says, you know, I have this debt, please don't let me get evicted. And I say to them, well, have you applied to stay DC? Too often the tenant will say, what? There just is not as much awareness of this program as there should be. So that's a big problem as well.
So why not
the federal law allows that some of the money can be used for marketing. So we could legislate, spend money on marketing, but they already can do that. And the fact that we would legislate it doesn't make them any more likely to do what they can already do. And that's true with many aspects of this. I think they've been talking about weeks about hiring more individuals, and I believe they have hired more to process these applications. And it is a little bit cumbersome in the process because if you think about it, somebody could be getting, I think the average is $7,000, $7,500 in payments. So we, the federal government, the district government, want to make sure people aren't defrauding the government or the program. So the applications need to be checked, but then there need to be enough people to check them. And the executive knows they need to hire people. We can't legislate to hire them faster. I mean, they just need to hire them faster. And when I say we can't legislate, I mean legislating doesn't make them do something that they already have the authority to do. Julie? Only generally, and that is that the emergency pretty much ties to access to the federal FEMA grants. Think of when a hurricane's coming and we know there's going to be a lot of power outages and down trees, and so the mayor will declare an emergency. The public health emergency goes further. The public health emergency allows the mayor to impose restrictions that would benefit the public health. So closing the bars, closing the movie theaters, requiring people to wear masks. And that's correct, except that remember public transit is government. So, and there's nothing that prevents an owner, in the case of public transit, WMATA is the owner, from requiring a mask or imposing other requirements. She can't impose that on private schools. She could on the public schools. I think we're extending it for about 90 days.
90 days past.
Yes. That would be for the emergency. And the concern there, as I said, is the access to FEMA money, which I saw everybody nodding their head when I mentioned the homeless shelters, because apparently the FEMA money is what is enabling us to use some hotels. I've been assured it won't be interrupted.
Try to understand better if there's no lead here on these for the victim side. Seems like-
Yes, and if I look like I have to rely on notes, I do, because it gets complicated. I mean, the concept is basically we want lower income folks to be protected, but we also want them to access relief, financial relief. And so I think actually one of the neat things about where we are today compared to where we are a few months ago is we say that a landlord can't proceed in eviction court if the landlord hasn't filed for state EC for the tenant, but anyway, an application has been filed. So the court says, okay, you know, this tenant is protected because they've gotten state EC.
Right, so it can still over the state, it seems like victim violations start if the landlord has filed.
I think the notices can go out sooner for non-payment of rent, but the filings are prohibited until October. And that's, eviction case is not covered by the exceptions. And the exceptions would be public safety, which could happen without delay, or the significant damage, which I believe can happen without delay. And for the very small housing providers, evictions not covered by those exceptions and that do not involve non-payment of rent could be filed beginning January 1st.
What other types of evictions are not non-payment, not ordinance, or not public safety?
There could be other violations of the lease, or it could just be that the lease is over and the landlord wants the apartment back. Oh, yes, it is. If you're my tenant, I shouldn't put it that way. If you are a tenant and the landlord wants your apartment for some other reason, and your lease is expired, and the district leases roll over automatically for 30 days, you know, month to month. So the landlord has the ability to evict.
And for those small housing providers, you reported it, is there a similar protection for their tenants that they can't be evicted unless they comply with state EC, or that doesn't apply to the small providers?
My note here is the housing provider must demonstrate the tenant's ineligibility at the time of filing. That would be ineligibility for emergency rental assistance. This is meant to provide relief to housing providers who cannot be made whole through state DC or other emergency rental assistance. So again, it is tied to state DC.
But if they can demonstrate tomorrow, I know my tenant's not going to be eligible, they can go ahead.
I'm pretty sure that we have elsewhere that the landlord has to demonstrate to the court that an application was filed. So I don't think the landlord can just say, I decided Mendelson looks like he's not eligible, even though it's publicly known that I'm not eligible, but you can't just simply say that. Yeah. Do I have to answer it though?
The police meeting today, basically leave the blame at the county.
Yeah, I think that's a cause and effect without any basis or proof. That's not even anecdotal. One of the more significant reforms that we adopted last year was that the police cannot bargain their disciplinary procedures. I don't, where's the nexus to that? And somebody shooting somebody else in, let's say, a domestic dispute. So I get that they don't like the change in the national attitude about policing. And but to blame that on the council legislation, there's nothing to back that up. And if they were to undertake a research project tomorrow, they wouldn't get any evidence to back that up. Well, you know, it's the increase in homicides here is consistent with the national trend, with a significant increase. It was your own paper had an article over the weekend that it's like since record keeping started 60 years ago, the highest year-over-year increase, and I believe the highest since around 1990, which is what, 30 years ago. It's very concerning, very, very concerning. And unfortunately, law enforcement isn't as good as I'd like it to be in understanding the causes of increases in homicide. And actually, to go back to your first question, as I recall, I don't think any other jurisdiction has adopted the legislation we adopted. So I blame our legislation for what's happening everywhere. It's interesting. There are a lot of different dates. So the utility disconnection moratorium will end on October 12th. And low-income residents will be protected for an additional 90 days if they owe less than $600. They received or were approved for benefits under LIHEAP, State DC, or one of the other financial benefit programs like CAP, which is DC Water. They're receiving SNAP or TANF, or they're 21 years of age or older and receiving a benefit under Medicaid or the DC Alliance. So we're protecting lower income individuals for a longer period of time.
Let me ask you a question, Mr. Chair. What about middle class people and what about landlords who are incurring debt each time, every time you extend this eviction filing and you prevent them, you know, even if they do get tenants who are eligible to stay, these landlords are incurring debt. What is the council doing on their behalf? Because it seems to me that it could be the council's action to actually be using landlords to the position of selling their building, which would further jeopardize or jeopardize tenants.
I would characterize it this way: we're opening the spigot. It's not being opened full bore, but there is money going to landlords now, primarily through State DC, but also the ability in a few months to be able to go after moderate and upper income means, so that they are able to get financial, I don't want to say relief, they're able to get the money that they're owed. I characterized it earlier as a soft landing on the removing the moratoria. That's both utility and eviction, a soft landing. So instead of it just ending, as I recall, the current law is 60 days after the public health emergency. So 60 days from now, the landlords can all go into court and they can file their eviction cases, and there's no restriction, no requirement that they have to seek relief, financial relief for their tenants. So that's the cliff. We're providing a softer,
Yeah, but the soft landing is for the tenants.
both.
I'm asking you, because of easy stay, you see that as a soft landing for landlords? You see that as helpful for landlords because they
Absolutely.
finally get their rent paid? But what about the debt that they incurred along the way? For example, maintenance, where they had to pay maintenance.
You're absolutely right, Janetta. But I look at it this way. There are a lot of tenants who will not be able to pay the rent that they've accrued. They just won't be able to. If the average stay DC payment is around $7,500, that's a fair amount of money, particularly for somebody who's lower income. They're not going to be able to pay it. So the landlord will never get their money. They could evict the tenant, but they'll never get their money. If they apply to stay DC, they'll get their money. So the landlord absolutely benefits. The problem is that some individuals, whether we're talking about tenants or landlords, kind of find it easier to do, I'll do it tomorrow or next week or next month or maybe never. And we're using the end of the eviction moratorium as an incentive to get people into these relief programs so the landlords get the money. That's $352 million. So, as I said before, housing providers will benefit and that extremely problematic tenants can be evicted under the exception that public safety eviction exception. With case filings allowed immediately for tenants who commit crimes of violence with rental property or causing significant damage to the property. They also benefit in that we're incentivizing people utilizing Stay DC. And small housing providers will benefit by being able to file eviction cases without having to wait until the end of the year if they can demonstrate that they are experiencing severe financial stress, or the tenant is not eligible for rental assistance, and the housing provider's financial distress will be mitigated or relieved by recovering possession of the units from the tenant. So, no, it's not complete, not pretending that it's complete, but that's what a soft landing is.
The benefits here accrue to low income people, as if there's no middle class people who have been affected by this. What is obviously state also has financial limitations on who can and who can't apply. So how do you, if you're incorporating in your legislation benefits that are, for people who are already going to benefit from CDC, where do middle class people in DC get benefits?
Well, remember, Stay DC is for people, it's not just for low income individuals, it's for people who lost their jobs last year and did not have income. So if you are ordinarily middle income, but you haven't worked and you don't have any income, then you would be able to apply to Stay DC. We're following Stay DC in terms of who's eligible. But it's not just, Stay DC is not just for low income people, it's for people who didn't have income last year. But there are people who have been able to pay their rent and haven't because they don't have to, in the sense that no consequences. One of my colleagues tells the story of somebody who came up to her and said, I'm not paying my rent, and when the moratorium ends, I'm moving. So I won't have to pay my rent. I don't know what his reference will look like, but there are people who are taking advantage that way. I don't see how, but I'm not saying this is a perfect world, Janetta, but the day is going to come for that person. They're going to get evicted.
The last thing I wanted to ask you about was the debt. I didn't get that on the election.
I doubt you were confused. Our debt collection law was written in 1971. That's pre-home rule. Minimally updated. I don't even know what that means. It doesn't include credit card debt. It doesn't include medical debt. When I say include, it sets forth procedures for debt collection and protections for individuals, but it doesn't protect them with regard to credit card or medical debt. Those are two examples. It also doesn't protect them from various stratagems that debt collectors use, like voicemail, because there was no voicemail in 1971. I think I was alive then. I don't actually remember. I do remember whether I was alive, but I don't remember if there was voicemail. I don't think there was. I think we had answering machines, maybe. And so we updated in that regard. So we expand the definition of debt to include all consumer debt, including medical debt. We prohibit excessive communications that constitute harassment, including making more than 3 phone calls in a 7-day period. We prohibit other deceptive behaviors, such as threatening action that the debt collector cannot take, or disclosing disputed information without disclosing that it is disputed, or threatening to disclose false information, or initiating causes of action where the statute of limitations has expired, or seeking to collect funds exempted by state or federal law, or seeking to collect debts owed by deceased consumers from those with no legal obligation to pay them. So we're updating the prohibition. We're defining the documentation that a debt buyer or other third party must possess prior to bringing a claim. We're incorporating the protections of the Federal Fair Debt Collection Practices Act, and we're placing a reasonable cap on attorney's fees.
And so my question, I think I've got all of that. My question was, you're doing this as an emergency, for a public hearing.
Correct.
Is there some reason
Correct.
why you think this is an emergency?
Correct.
Or is the AG using this is he being opportunistic and exploiting the situation with the pandemic and stuff as a way to get legislation moved on that he wanted?
Well, I won't speak to the Attorney General's motives.
Well,
I'm
you're
introducing
also
this.
doing that, then.
Well, of course not. The impetus for this as an emergency is that the public health emergency is ending, and we have debt collection protections in place right now in the tied to the public health emergency. Basically, we've prohibited almost all debt collection during the pandemic, and that's going away with the public health emergency. So rather than just simply having a trigger of, let's say, November 5th, which is for most of the provisions, we're doing this.
You could do it as a regular,
I introduced the bill today.
you introduced the bill today,
Yes,
and you're passing it as an emergency.
correct.
You could technically move it along even as you're doing the budget stuff and incorporate it, right? Or
Not in the
before
Janetta
November
Barris.
5th.
We're not going to incorporate it in the BSA. It hasn't had a hearing. So, let's see, we could not move the emergency and we could put the November 5th trigger in there. But we have a pretty good pretty good revision. So why not get that into effect now? And the permanent will move along. Introducing the permanent today, the earliest it could be a hearing would be in October. And there's no way that the permanent would be effective until a year from now, meaning like next spring, March or April. And we'd have to do an emergency then.
Can I ask you also a budget-related question?
What if I say no?
Well,
Oh, come on.
these times have made me nicer, Mr. Chairman.
Really?
Right. So with respect to the budget, the last section that the council colleague, Christina Henderson, brought up the higher income tax. Where is that? Are you planning to have just a discussion on that alone? Or how are you managing that as it appears there are at least 6 people on the council who want this tax?
Yes, I have said repeatedly that I don't think we should be raising taxes when our revenues for the budget next year are a couple $1 billion more than they were last year, the year before. I mean, really, we have so much money. I recognize what you're saying, that there's a significant number of members who want to increase taxes regardless. As you know, the process with the budget is that I will be preparing a committee print. What every committee chair does with a bill that's in their committee and the budget's in the committee of the whole, I'll be preparing a committee print. I do not expect that the committee print will have a tax increase in it. So if there is a proposal for a tax increase, it will be moved as an amendment. I would, of course, discourage that. But if I don't have the votes, I won't be successful. We will do everything we can to circulate the committee print next Monday morning. That's the day before the legislative meeting. Yes.
So if your expectation is what is your
I think because of the work that my staff has done, and I'll call out Plain Stone, we've worked closely with a lot of the legal service providers and others outside of the government who care about this issue. And I cannot say that they're all are full-throated support of this, but we've tried to answer their concerns and mitigate concerns that they've raised. And my sense from other members is that members feel that this is a better place than where we were when I tried to move this before. I mean, that is the legislative process, is you put out something, if folks don't support it, then you work it some more. And I think members realize, and I hope that the public realizes, that if we don't do something, then we will have a more severe consequence, what I referred to before as a cliff. It will just be here, and the courts will be overwhelmed with eviction cases. Consumers will be, there'll be a large number of consumers getting utility disconnections. There will not be a soft landing. And you know, the beauty of what we're trying to do is encouraging utilization of the $350 million. And I think there actually could be over time a little bit more than that because of utility and some other assistance to leverage that. And the effect will be that the landlords get what they're owed, or most of what they're owed. Individuals, tenants will get rid of their debt that they will have. If it doesn't get paid, they will have their debt. And we should be reducing the number of evictions. In fact, I saw some data, this was a month ago, I looked at this. I hesitate because I don't have it in front of me, but looking at Virginia, and I don't think of Virginia as being as progressive as the district, but Virginia at the beginning of this calendar year tried to tie evictions to access to relief funds and saw a dramatic drop in the number of evictions this year compared with pre-pandemic, a dramatic drop. So if the goal is to eliminate any more evictions for the rest of time, that's not going to happen. That's not going to happen. Certainly not going to happen if we just allow the current law to expire. And but if the goal is to get people to reduce the debt and pay their bills with the federal assistance, this does a better job of it than anything else I've seen. there no other questions? Thank you all very much. See you tomorrow at noon.
Welcome back to the
Yes.
book.